Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Here, all persons having business with the Appellate Division, drawing near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. Nice to see everybody today. We do have over 5 hours of argument time that's been requested, so I please ask you to try to keep the amount of time you request to a limited amount. Remember, we've had your briefs and your records, and we are familiar with your cases, and just hope that you will get to the heart of the matter, and of course, we'll ask you some questions. When the white light goes on, that means you have 2 minutes left. When the red light goes on, that means you should finish up your sentence and you're finished. Of course, if we still have questions, we're allowed to go over the red light for that. Okay, so let's call the calendar. Both sides, please stand up and let me know how much time you would like. People versus Michael Straker. Okay. 4, 1, and 4. Thank you. Board of Managers versus 732 West End Avenue. Okay. Okay, 5, 2, and 5. C. Tamikwa versus David B. Submitted. U.S. Bank versus 21647. 5 and 2, and is the respondent here? Okay, 5, 2, and 5. Thank you. IZ and Infant versus West End Residences. Excuse me? 3 and 2. Is the respondent here? Do you still want to argue, or do you want to mark it submitted? Okay, thank you. We'll mark it submitted. Osorio versus Punjab Enterprises. How much? Well, you don't have a cross appeal, so you just get one. All right, I'm going to give you 5 and 2 and give you 5. Thank you. People versus Antoine B. is submitted. Capstone Capital versus DCK and Arena. Okay, submitted. Picardo versus Irizarry. Okay, I'm going to give you 5, 2, and 5. If you need more, we'll go on a little longer. People versus Kevin White. Okay, so I'll give you 5, and I'll give you 5. Footman versus D'Onofrio General. Okay, respondent. Okay, 5, 2, and 4. People versus Pedro Ortiz. Okay, respondent. Okay, 4, 1, and 4. Lugo versus New York City Housing Authority. Okay, 5, 2, and 5. Seems to be our numbers today. And the last case for argument is Mejia versus Super P57. Are both sides here, or? Appellant is not here. Do you still want to argue? I don't think we have any questions. So, okay, we'll mark it submitted. Okay, thank you. Okay, that's concludes the call of the calendar. The first case for argument is People versus Straker.
If I may.
Yes, good afternoon. You may proceed.
Good afternoon. The Legal Aid Society by Ivan Pantoja for Ms. Straker. We respectfully request that Ms. Straker be adjudicated a level 1 offender for 2 reasons. First, because the SOAR court inappropriately assessed points under risk factor 7, and had the court properly scored Ms. Straker a 95, it would have then adjudicated Ms. Straker a level 1 in appropriately finding that a downward departure was warranted. Now,
Oh, wait, one question. I guess my first question is, why wouldn't a remand be appropriate for that adjudication at this point? And then you can go into your arguments about the downward departure.
thank you. So there are 2 reasons why I believe remand would be inappropriate or perhaps unnecessary. First, the prosecution was given ample opportunity to present evidence, first regarding risk factor 7. Not only did the hearing take place over the course of 2 days, separated by, I think, almost 2 weeks, but they also had the opportunity to submit paperwork in advance of the SOAR hearing to support their request for points or their opposition to a downward departure, for example.
When I look at the record, I think I saw that the prosecutor was going to make an argument as to the assessment of these points on the factor 7, and the court said, the court basically stopped the prosecutor in his tracks, or her tracks, and said, I don't want to hear it, and moved on. So don't you think that the prosecutor should be given an opportunity, like my colleague suggests, to at least make a record as to why points under this factor should be assessed?
Yes, and I guess I'll address that in 2 parts. First, again, just to note that they did have ample opportunity, two days of a hearing. We did come back, they did come back on the 2nd day to address the downward departure. So I think at that point, the prosecution could have further provided additional support. But if your honors are inclined to remand for that purpose, I would ask that the prosecution be limited from providing additional information that they didn't have at the time of the SOAR hearing. I think that would only be fair that they would provide or be limited to the information they had at that point. And I guess if your honor is inclined to do that, I think the purpose would be, I think, primarily to address the downward departure. Here, as you know, and I'm referring to the appellant as Ms. Straker, the main basis for the downward departure was her transition to being a woman who a transgender woman who identifies as a woman. And there was extensive information provided in the mitigation report on how that change in her life and those circumstances further reduced her risk of recidivation.
That would all be something that would be heard by the court. I mean, that's the whole point of sending it back down for a hearing. It does seem, in looking at the record, that the prosecution did not get an opportunity to really speak completely on that issue, and maybe neither did the defense, because the court said, we're not really going to deal with that issue, and I've made my decision.
In regards to risk factor 7, is that?
Excuse me? Yes, as to factor 7, exactly.
Yes, I understand. Just to note that I don't think there would be any additional information that would necessarily be provided that wasn't already provided to establish the fact. First,
Counsel, the issue about Ms. Straker now being a transgender woman, that was brought up below, and that was the basis the court did, in fact, issue a departure?
That's correct.
And so you're asking for an additional departure based upon that reasoning?
Well, yes, so the basic point is that if the court had properly not assessed 20 points under risk factor 7, we would be at a presumptive level 2. And then based on the information provided in the mitigation report and her transition into being a woman, that merited a downward departure. Our argument is that downward departure should go from 2 to a 1.
Okay, I think we understand that. Let's hear from the prosecution, and you'll have a moment for rebuttal. Thank you. Good afternoon, counsel.
Good afternoon, Your Honors, and may it please the court. Kalani Brown on behalf of the Bronx County District Attorney's Office. Your Honors, we respectfully request that this court affirm the SORA court's ruling adjudicating the defendant a level 2 risk, or in the interest of justice, remand so that there may be further additional findings of fact to determine whether points were properly assessed under factor 7 for a stranger relationship. Your Honors, the defendant was initially assessed 115 points for a level 3 adjudication, and so the SORA court judge only granted a downward departure, as Your Honors mentioned, based on the defendant's transition and based on the fact that the defendant was 5 points away from a level 2 adjudication. Taking away the 20 points under factor 7 would still adjudicate the defendant a level 2 risk, and in that sense, it cannot be said that the judge would have granted a downward departure from level 3 all the way to a level 1 just because the defendant was given 95 points instead of 110.
But we can agree that the record doesn't really reflect the court making an adjudication or giving the prosecutor an opportunity to address it on the factor 7. It's just not there in the record, right?
Yes, Your Honor, that is correct. There is no information, there's no findings of fact to determine that points were properly adjudicated under factor 7. There was only the judge's conclusion that there was indeed a stranger relationship for the purpose of victimization. However, as Your Honor has mentioned, the prosecutor did not get a chance to make her explanation or findings to assess points properly under that factor.
And would you agree that the Supreme Court would be allowed to only make conclusions based on the evidence that's already been introduced at the time of the SORA hearing?
Yes, Your Honor, but in addition to that, the prosecution was able to read certain portions of the grand jury minutes into evidence at the SORA hearing. So if in the event that the prosecution would like to read portions of the grand jury minutes to prove the points assessed under factor 7, then I believe that the prosecution should be able to do so.
But that was done at the last hearing also?
Yes, Your Honor, but for a different factor.
Are you referring to additional portions of the grand jury minutes or the same portions of the grand jury minutes that were already read to the court?
Possibly additional portions of the grand jury minutes if there were portions that the prosecution wanted to make an argument, wanted to make a basis for its argument. However, it cannot be said that the prosecution would have used the exact phrases or statements, testimony from the victims to then prove the basis for a factor 7 point assessment. And so if Your Honors have no further questions, we respectfully request that the defendant be adjudicated a level 2, but in the interest of justice, if the court finds that further findings of fact be determined, that a remand be necessary. Okay. Thank you.
Thank you.
Unless Your Honors have any additional questions, I'd just like to thank you for your time.
Okay. Thank you. Thank you both. Okay, the next case for argument is Board of Managers. Good afternoon.
Good afternoon. May it please the court. David Abramovitz for the Appellant Board of Managers of Petit Verdot Condominium. The condominium offering plan at issue in this case contains the following explicit promise, and I quote, Upon the dissolution or liquidation of the sponsor, the principals of the sponsor will
Counsel,
provide.
you filed an amended complaint down below, correct? That
That is correct.
and that excises this claim, right?
The amended complaint explicitly and affirmatively reserves its rights on this issue, given the pendency of.
It does reserve its rights, but does it assert a cause of action?
I'm sorry, I didn't hear the
How
question.
do you mean it reserves its rights? I mean, is there a cause of action based on this theory?
In the amended complaint, there isn't, since the lower court had dismissed it. There is a cause of action, let me strike that. There is a cause of action. The lower court did not dismiss with respect to the same claim as against the sponsor entity. It dismissed.
No, I know
solely with
that,
respect
I
to-
know that, but the claim against the two individuals, Sackman and Heffelfinger, didn't you, isn't that, are they in the amended complaint still?
Not on the breach of contract claim, because the lower court had dismissed it, had dismissed the case. It would have been frivolous for us to reassert the exact claim that the judge had just dismissed.
Thank you.
And hence this appeal. The substantive question here is whether the explicit promise by the sponsor's principals, who are indisputably signatories to the offering plan in their capacities as principals of the sponsor, whether having made that explicit promise to take action on the dissolution of the sponsor and having failed to do so, there is a
Counsel,
remedy for.
isn't this, I'm sorry to keep interrupting you, but isn't this argument totally foreclosed by Board of Managers of Lore versus Gateway number 4?
It is not, and it isn't for the same reason that the other cases don't bar this claim. In every one of those cases, including Lore Condominium, the claim sought to hold the principals of the sponsor liable for the sponsor's breach of the sponsor's obligations, and not for the principal's breach of the principal's obligation. In Lore Condominium, as in most of the cases, they sought to hold the principals liable for the sponsor's failure to properly construct the condominium's building. There are no appellate cases in this state which have addressed the question whether there is a claim for the principal's failure to comply with their obligation under the offering plan to furnish a financially responsible successor if the sponsor is dissolved. Now, the issue has come up before this court, albeit in a little bit of a roundabout way. It was before this court in the Beat William case decided a couple of years ago, but in the context of a DCL 276 claim for intent to defraud, and there was a discussion in the lower court's decision as to whether that constitutes one of the badges of fraud. And this court ultimately affirmed a grant of summary judgment on the DCL 276 claim. But the question of whether it's a breach of contract claim on the offering plan, which New York law and this court have held repeatedly constitutes a contract, whether there's a breach of contract claim for the principal's failure to comply with their explicit promise that they, the principals, will take action.
What about the assured guarantee case versus J.P. Morgan from the Court of Appeals? It says, and I quote, "A private litigant may not pursue a common law cause of action where the claim is predicated solely on a violation of the Martin Act or its implementing regulations and would not exist but for the statute." Isn't that the situation that we have here that just absolutely forecloses plaintiff's cause of action as against these individuals?
That verbiage, which shows up in many of the appellate cases as well, sort of says more than it means, because we know, for example, that one can sue and is not foreclosed by the Martin Act if there's an affirmative misrepresentation in an offering plan. The law is also clear that one can sue for breach of contract, for breach of an obligation in the offering plan, even where that obligation is one that the sponsor is required to undertake in the offering plan.
Well, Counsel, I just want to go back because, first of all, the principals were not parties to the offering plan, correct? That's a yes or no. Were they parties to the offering plan?
Yes, they are. They signed the certification to the offering plan in their capacities as principals.
Right, but we'll probably disagree on whether or not they were parties, so let me move on there, because they're required to sign the certification under the Martin Act and the regulations, correct?
Correct. They are, for lack of a better term, that's the price they pay for wanting to be involved in an offering of condominium securities. I would posit, I would.
So I want to take it further.
Sure, go ahead.
So can it be said that they're really, well, let me say it this way, that you're really hanging your hat on that certification that they're required to sign by law. Is that fair to say?
In part, yes, but it's not solely by virtue of them signing a certification. It's that they sign a certification to an offering plan in which they are certifying the accuracy of their promise that they will undertake this specific action, which they then fail to do.
Okay, thank you.
Thank you.
Okay,
I see I'm
let's
out of
hear
time.
from, okay, thank you. Let's hear from your adversary, and you'll have a few moments to rebut.
Good afternoon, Andrew Gaffel, Abrams, Garfinkel, Margolis, Bergson for the respondents. Our position is that the lower court got this question correct following numerous appellate division decisions from this court and the Second Department. And to quickly summarize, this breach of contract theory simply is not how contracts work. As we set forth in our papers, there's no dispute in fact or law that an offering plan, the contract that's allegedly breached here, is a contract between a sponsor, here the WEA entity, and the unit owners. And as a matter of law, only those parties are possibly liable for breaching that contract. Furthermore, this particular provision in this particular contract that was breached is in a section that is under the title Rights and Obligations of the Sponsor. So, even further emphasizing that this obligation was expressly undertaken by the sponsor, and indeed, only the sponsor is capable of undertaking this obligation as the only party to the contract, or counterparty, as it were. The hook to get around this is the certification that was brought up earlier, and the lower court, again, correctly found that this certification is signed pursuant to the Martin Act and its implementing regulations. It states that it's signed by the sponsor in their capacity as principals, and all this language, by the way, is imported word for word from the Martin Act, and that, they're signing in their capacity as sponsors, and they're signing it for the purposes of certifying that the contents of the offering plan are true and correct. So that's what they certified. They didn't purport to certify, and they're not capable of certifying contractual provisions in the contract itself. And again, this question has been raised and decided at least 4 times by 4 different appellate division decisions and numerous trial court decisions in our papers. As I understand appellant's arguments, it's that this particular provision is of a different type than other provisions and other offering plans that have come up. But that's a distinction without a difference. That doesn't change the result. I mean, the fact that it says the principals of the sponsor shall provide a financially responsible individual in certain circumstances, that doesn't change the fact that they didn't obligate themselves to any contractual obligations. Indeed, an offering plan imposes numerous obligations on the sponsor. Numerous of those obligations are going to be performed by parties other than the sponsor. That doesn't mean that those third parties who performed, whatever hypothetical we want to come up with, are, liable for breach of contract for a contract they didn't sign. The sponsor is obligated to perform X. If some non-party performed that obligation here, the non-party being the individual principals of the sponsor, they're going to perhaps on the ground perform this obligation. It's still the sponsor's obligation, and if it's breached, the sponsor is liable, not the non-party individuals. There was one case in the reply papers of appellants that I wanted to point out on this, the Martin Act issue, and that the Martin Act does not provide a private cause of action. The South Star decisions on page 7 of the reply. That decision, there's language in that decision that says, the Martin Act doesn't preclude a breach of contract claim. But if you look at that decision, the breach of contract claim was against the sponsor entity only. There were other claims in that case against the individuals, but they weren't breach of contract claims. So we respectively submit that the lower court got it correct, the law is clear, and that portion of the order should be affirmed.
Okay, thank you.
Thank you.
Just a couple of very quick points.
Sure.
One, the notion that a breach of contract claim with respect to an offering plan can never reach the principles of the sponsor is legally fallacious. We know, for example, this court in the 184 Thompson case pointed out specifically, and in a couple other cases, that they are dismissing a breach of contract claim against principals for the sponsor's failure, but note that there were no allegations that would allow a claim against the principals for alter ego theory. So the notion that one can never reach the principles under a contract theory for breach of an offering plan is fallacious. Two, just very quickly, this notion that there are other obligations in an offering plan that are practically going to be done by someone other than the sponsor is somewhat of a red herring, because in every one of those cases, it is the sponsor that is ultimately liable. So constructing the building is going to be done by the contractor, not by the sponsor themselves. The sponsor has the responsibility, and we all know the sponsor can be sued for breach of contract if they don't construct properly. The question is whether this promise, which doesn't say the sponsor will take action and doesn't say that others will fulfill a sponsor responsibility, is simply empty words for which there's no remedy, or whether it's to be treated as a real obligation by the parties who are making a promise to undertake action. And it's not parties who don't sign on to this document, who are complete strangers to the document. It's the principals of the sponsor who sign on to the offering plan, knowing that the offering plan contains this promise by them that they will undertake certain actions.
Look, but you have to have people sign a contract, and the law seems to have developed from the Court of Appeals down that just signing on to that document is not enough to bring these kinds of lawsuits.
Correct, but Your Honor, it's a combination of things. It's not the mere fact that they signed the document that makes them liable. It's that they signed a document in which they make a specific promise that they will undertake action. That's different from signing a document that says the sponsor entity will take action.
Okay. All right, thank you both.
Thank you, Your Honor.
U.S. Bank versus 21647.
Good afternoon, Your Honors.
afternoon.
May it please the Court. Your Honors, respectfully, the lower court erred in granting non-party intervention in this matter. It's incontrovertible that non-party was aware of this action from inception and deliberately waited 6 months before seeking intervention. This court has long held that before any motion to intervene is considered, the first factor is the timeliness of the motion. And also...
Well, was there any prejudice to your client because they waited the 6 months?
There was prejudice. We had dispositive motions pending at the time. We were litigating with the defendants, and non-party then decided 6 months later that they wanted to participate in this action. And there's no debate that they were aware from inception. This is a scenario where it's the mother of one of the defendants.
Well, the defendant as general manager of the company, right?
Right, exactly. So the court shouldn't have granted intervention in this matter.
But you did know that the entity that transferred title to Ms. Plotch, they were in the case already, and you knew what their claim was, correct?
Right, we did.
So doesn't that undercut your claim of prejudice?
Well, the plaintiff shouldn't be forced to litigate with multiple parties.
Well, but Ms. Plotch is just stepping into the shoes of 21647 LLC. That's all she's doing.
Right, and we were litigating with both parties, and she didn't claim that she was stepping into the shoes. She attempted to assert independent rights that are different than those of 21647, the corporate.
Well, let me go back a minute. So one of the claims that you make in your brief is that they didn't include a copy of a pleading pursuant to the CPLR, and therefore the motion should have been denied on procedural grounds before we even get into the merits. So where and that there was not even an affidavit that backed up the motion that explained exactly what the claims were. So where did you learn of whether they were stepping in the shoes, they're not stepping in the shoes of 21647? If I got those numbers right.
Well, I'm not certain if I completely understand your question, but they never claimed that they were stepping into the shoes. They never said, we're submitting this claim as successor to 21647. They just filed this motion without a pleading, as Your Honor indicated, saying we want to seek intervention and dismissal. And, you know, I don't know if I'm properly
Well, so
answering.
let me
Yeah,
let
sorry.
me go to another issue.
Sure.
How are you, assuming all of that there's problems or potential problems with that, you've made your point, how are you going to get by the statute of limitations on this particular case? How that's what I'm trying to figure out.
Sure. So we
Which is kind of the key issue.
we relied on CPLR 205A, which was the law at the time of
In
commencement.
parentheses, A.
Yeah, which was the law at the time of commencement of this action. And we satisfied all three prongs, and it was our position that Your Honors had dismissed the prior action pursuant to CPLR 32-115C, which at the time was you were allowed to recommence under CPLR 205A. And that in dicta, you had mentioned that there were certain jurisdictional concerns. Notwithstanding, we are of the position that even if we can't recommence against the party where there was jurisdictional concerns, we can commence against the corporate entity that acquired the deed. So it didn't preclude us from commencing, even if it was dismissed for lack of jurisdiction, that it didn't preclude us from commencing against the corporate defendant, 21647.
Does it matter the status of these two parties and how they interplay? Like, were they indispensable? Can we now extend that lack of the statute of limitations argument to the other party?
Was which party indispensable?
Well, I guess my question is, if there's failure to obtain jurisdiction over one party, does that extend to another party?
In the prior action?
Yeah.
So this court had issued a decision saying that they thought the failure to acquire jurisdiction in dicta again would have required dismissal against the other party. I had noted that
Those were the two original.
the two original borrowers. I had noted in my papers that actually wasn't the case. Title had been extinguished, and they weren't subject to deficiency because one party hadn't signed the note. So it wasn't necessary to dismiss against the party as a result of a lack of jurisdiction. But you know, that's in the past now. That was a decision of this court back then. I sought re-argument on that grounds, and admittedly, I lost. But again, notwithstanding, I don't think that precludes us from commencing against the corporate defendant. And then I provided a Fourth Department. It's not a common fact pattern, but I provided a Fourth Department decision that addressed this precise issue.
Okay, let's hear from your adversary, and we'll give you some time to respond.
Sure.
I just want to make sort of one comment. You said we said it in dicta. Now, a couple of us were on that panel. I don't know how you're telling me we said this in dicta. It seems, seems to me this is part of our decision. But you can think about that during his argument and address it when you come back, okay?
Sure.
Okay. Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is John Muldoon on behalf of non-party respondent Batia Plach. And if I may begin by hearkening to the exact question you asked, Your Honor, of how you get over the statute of limitations, and the answer is that you don't. In this case, as this Court held twice, in what we've been calling the Shea decision, it noted twice that future enforcement of this mortgage would be barred. Plaintiff saw that decision, decided to purchase the mortgage after the fact, and commence a new action in light of that decision. And there's any number of reasons why the statute of limitations bars this action. Counsel brought up CPLR 205, but that statute is inapplicable for any number of reasons, which all lead to the exact same conclusion. As the Court of Appeals definitively held in Ace just past year, when two different plaintiffs are trying to enforce the same right, they are not permitted to avail themselves of CPLR 205. In this case, it's undisputed that HSBC Bank prosecuted the first action. It was dismissed, and now a different entity, U.S. Bank, is trying to enforce those same rights. As Ace in the Court of Appeals and as the Foreclosure Prevention Act that was just passed both make explicitly clear, that's not permitted.
Well, counsel, what about the argument that your motion to intervene should have been denied because there was no pleading attached?
Sure, Your Honor. So for two reasons, there's precedence from this case law which states that a motion to intervene does not require a pleading, but also...
Well, I mean, we took a look at that case, but if you look at the CPLR, I'm not sure that that was necessarily 100% accurate. I mean, there's CPLR 1012 and 1013 and 1014 that all deal with intervention as of right and intervention under other circumstances. And 1014 seems to say that a motion to intervene shall, not may, but shall, I lost the page, but, you know, shall contain, shall be accompanied by a proposed pleading setting forth the claim or defense for which intervention is sought. So how do you get around that in the first instance? I know what the case says, but let's put the case aside. Let's see what the CPLR says.
So in this case, Your Honor, when we moved for intervention, we also moved to dismiss on 32A5. That's our proposed pleading. It's a pre-answer motion to dismiss. So basically, as the precedent holds, when you make clear what your claims and defenses are in your motion to intervene, that satisfies the requirements.
But Ms. Plog was not a party at the time. So she's a non-party moving to dismiss an action where she's not a party.
She moved to intervene, and then once intervention...
Yes, but if the motion to intervene, if the papers are defective, and the motion, therefore, should not be considered, how could the court then consider her argument to dismiss?
Your Honor, it's also my understanding that that was the exact scenario in the first case around here, where a non-party both moved to intervene and dismiss on 3215 grounds. Respectfully, it's the exact same scenario in which they moved to intervene and dismiss in the same motion.
It could be, but first you have to be granted leave to intervene before the court can entertain then your second argument to dismiss, which is exactly what the court did here. But what we're saying is if you don't have your pleadings attached to the motion, then the motion is defective. And therefore, the court should not consider it.
Your Honor, I would still maintain that a pre-answer motion to dismiss is the pleading. You wouldn't answer and then pre-answer move one after the other. It would satisfy that requirement.
Seems like the parties in this case are constantly moving. I mean, the plaintiff changed 5 times, and you defendants keep switching around also. So it's like movable parties in this case.
I don't disagree with that fact, Your Honor. But if there are no more questions from the court, we'd obviously reside on our papers and respectfully conclude that the appealed order be affirmed.
Okay, thank you.
Thank you, Your Honors.
Thank you, Your Honors. I don't...
Counsel, just before you get started, just on that last point about the motion to intervene and your adversary's argument that the motion to dismiss was in fact the pleading that was attached and the motions, they were all intertwined. Does it matter that Batia Plotch didn't submit an affidavit?
That was my understanding of the law, is that the cases that did allow for an exception to this inclusion of a pleading, of an answer, did so because there was an affidavit from the defendant setting forth the defenses. And again, as this court noted, this was a non-party and there was no affidavit included with the motion. Your Honors, I'd just like to briefly respond to a couple points raised by my adversary. First, let me start by responding to your question about whether the jurisdictional issue was dicta. Certainly, you would be in a better position to tell me. However,
Certainly.
certainly. However, I believe that you set forth a dismissal under 3215C. The case couldn't be dismissed twice. You provided grounds for a dismissal under 3215C, and that the rest was basically the court telling, even if we didn't do this, we would find this way. But again, I don't feel like that is a fatal issue to commencement of this action, because we're not seeking to foreclose against the borrowers, and it would be the borrowers that would have to raise this defense of jurisdiction. One issue that wasn't discussed, but I'd just like to briefly note that we had raised that the prior entity didn't have standing to foreclose. They included a note with the complaint in the prior action that was unendorsed.
We saw that
Yeah.
argument, and, I mean, isn't that a little too late, a little too late? I mean, that case has already been decided downtown, and we already made our decision over 2 years ago on that. You didn't argue that, or that wasn't argued below. There was no issue about the standing. So now, 2 years after the appellate division decision, You're saying that there was no standing?
It wasn't litigated. Standing was never part of that litigation. The issue was solely with respect to 3215C. The argument was never, was there standing to accelerate?
I'm just trying to understand how several years later you can attack the standing in another, in another case that's long been over.
I believe I referenced a First Department decision in my papers. I'm just trying to find it, where a First Department decision where this court held that in a subsequent foreclosure action, you could, in fact, address whether there was standing to accelerate in the prior action. I believe this court, directed that there would be a trial on this issue. They sent it back down to the lower court.
All right.
Are there any other
Does anyone have
further
any other
questions?
questions? Well, I, for one, find this a little bit confusing, but we will certainly take a look at your papers and
Okay. I thank
figure it
the court
out.
for its time. Thank you.
Okay, thank you both very much. The next case for argument is Osorio versus Punjab Enterprises.
Good afternoon. May it please the court.
Yes, please, go right ahead.
My name is Murad Sardar from Molad Spitz and DeSantis. I represent the appellant in this matter. We believe the lower court got it wrong on several fronts in holding that although my clients established a prima facie entitlement to summary judgment on the issue of threshold, that the plaintiff provided sufficient evidence to rebut that presumption. We believe they made a mistake on several fronts. First being that the lower court completely disregarded and didn't even discuss the multiple gaps in treatment that spanned months and years for both the cervical spine and the right knee that went unexplained or insufficiently explained.
I mean, the accident was, what, in April?
April 9th of 2015.
And she had a discectomy a year and a half later. I mean, people don't go, she was a young woman. She was 17 years old when this accident happened. She went to the doctor and eventually went to have a discectomy. I mean, I think that there may have been certain times that she wasn't going to see the doctor. I think she was still in high school. She lived with her mom. She was going to see people. I mean,
Your Honor,
I never liked that defense too much personally, but I don't really see that in this case you could stand on gaps in treatment.
so if I can address that, Your Honor, with respect to the cervical spine that she had the discectomy for.
Right.
She stopped treating in August 12th of 2015 and had no other treatment, and that's not explained by her doctors, where they say you don't need to treat, which is what's required under Pommels and its progeny, until she sees a doctor in September of 2016. So that's a 13-month unexplained gap in treatment. She didn't actually do any treatment. Then she sees another doctor, Dr. Kaisman, 2 times, and then has a discectomy. So there isn't an ongoing treatment. There's literally a gap in treatment, which according to Pommels, breaks the chain of causation, even where there's objective medical evidence of an injury, which is what we have here. Furthermore, there's gaps after that. There's gaps after she has a discectomy, and Your Honor,
She was pregnant, her mother didn't want her to have certain treatment. There was testimony. She was in school, she was trying to work things out. I mean, I think you were selectively reading the record, counsel.
Your Honor, there is a bunch of statements in that deposition where you said she's pregnant. That's fine, but that doesn't address after she gave birth and why she didn't seek treatment after that, which spanned another year before she has the fusion surgery.
Counsel, is it your position that her testimony on these particular issues is not enough? Or is that how I'm understanding you?
No, it's been proven to not be true, specifically. So in the Gonzalez versus AV management case, which is before this first department, the plaintiff gave the same types of reasons. One of the reasons being that my doctor told me I shouldn't treat anymore, that it's not going to help me. But the record itself, the medical records disprove that, because the doctors actually said you should perform further treatment. But that's not what happened. So in that case, the court held because of that inconsistent reason, it found that the plaintiff's explanations were not actually reliable. And if I can move on to the submissions. So plaintiff's submissions don't establish issues of fact, because Dr. Benatar, the expert that they're relying on primarily, doesn't address any of our experts in rebuttal, literally none of them, because the expert report from Dr. Benatar was tailored only to address the co-defendant Agramante's motion, and simply because he doesn't mention any of our experts, Coyne, Dr. Waite, or Dr. Carcienti. Dr. Coyne found, after the accident, the May 2015 MRIs, the plaintiff had a degenerative condition in her cervical spine. Dr. Benatar's report is completely silent.
A degenerative condition on her cervical spine at the age of 17?
Well, Your Honor.
How is that explained?
It's explained by a degenerative condition. Dr. Coyne found that. Dr. Benatar doesn't rebut that.
Degenerative at 17?
At 17.
Oh, come on.
Well, Your Honor, even Dr. Benatar says that is possible in his report. He says it's possible. Now, again, you want to look at
So he does address the issue of degeneration?
No, he didn't. He addressed the issue of herniations, and he said that's not common, but doesn't address degenerative conditions because he wasn't addressing Dr. Coyne's report. And, Your Honor, as a matter of law, several cases after Linton versus Nawaz, which plaintiff...
So if your doctor says that the moon is made out of cheese, then the plaintiff has to get an expert to say, nope, the moon is not made out of cheese, it's made of something totally different.
Well, Your Honor, if I could respectfully...
Is that the way you're framing it?
I could respectfully address that. The lower court found that we established our prima facie case entitling us to summary judgment on the issue of causation. They found that. So the issue then goes to plaintiff's proof. And if plaintiff's proof is not sufficient, and it's not as a matter of law, Your Honor, the Arroyo versus Morris case is instructive from this court. In that case, the defense expert found that the plaintiff's MRI showed degenerative conditions. The defense expert was completely silent, the plaintiff's expert was completely silent as to that issue. And the court held, specifically, without explanation for ruling out these conditions, the degenerative conditions that the defense expert found as the cause of the injuries, the doctor's opinions that the injuries were caused by the accident are speculative, and the court dismissed plaintiff's complaint.
What about the MRI? What about the MRI report? The plaintiff's doctor submits an MRI report that says that these conditions are causally related to the accident and that they are not degenerative.
Your Honor, which doctor actually said that? No doctor says that.
The first doctor
He's not here to answer your question.
The first doctor that did the MRI report, the first MRI, which was done about a month after the accident, says that she's got this condition. The condition is not listed as degenerative, and that it's causally related to the accident. Isn't that sufficient evidence?
Your Honor, I respectfully disagree with that because it doesn't say that in that report.
Okay, let's hear from your adversary,
Thank you.
and then we'll listen to you again for a couple minutes.
Good afternoon, Your Honors. I am Michael Dallas, and I represent the plaintiff, Ms. Osorio, and I would like to say that I don't think that the defendant's motion for summary judgment was wrongly decided by Judge Hummel in the Bronx because she clearly evaluated each of the doctor's reports that were submitted to her by both the plaintiffs and the plaintiff's experts and also the defendant's expert.
Well, let's talk about the plaintiff's, Dr. Benatar, on the issue of the knee injury. I mean, I read the report, and there was literally one sentence in there just saying that, you know, it didn't really explain the pre-existing conditions that were raised by the other doctors. Do you want to address that?
If I understand your question, Your Honor, Dr. Benatar reviewed the totality of her medical records. This was an athlete at Mott High School in the Bronx. She was 17 years old at the time. She had a injured growth spur in her right leg that she was on her way to the doctor to have the cast removed when the collision occurred between a 66,000-gallon tanker truck and her car. She was sitting in the front seat with her godfather. She continued straight on to the doctor's office after the hysterics that she was experiencing. Which she was calmed down, the police came. They went straight to the doctor's office. She was examined by that doctor. The cast was removed and reapplied. And then she went directly to, not directly, about a week later, she went directly and she started to be treated by chiropractic treatment. And then she continued on. She was a very ambitious child. Her dream was to be a New York City police officer. She was on the swim team. She was on the softball team. She was in negotiations with Penn State concerning a possible scholarship. When she could no longer compete in her sports at high school, she changed her dream. She decided to join the Coast Guard Auxiliary, and she passed the boating exam, but due to the cervical injuries to her spine, she couldn't pass the swimming portion of the Coast Guard Auxiliary. That destroyed her dream of using the Coast Guard Auxiliary.
So, okay, so about the cervical spine, or any injury, do you want to explain, your adversary seems to make a lot of points about the gap in treatment. Do you want to address that?
She addressed that herself in her deposition. She said that she has a very conservative immigrant mother that was concerned that she needed to mature as a person. She was 5'2" and 110 pounds at the time of the accident. She was 17 years old. She was a sophomore in high school. Her mother was very cautious about the type of treatment she had. So also, she had several months of the chiropractic treatment, and then she did treatment on her own, and I think it's valid that can be authenticated with her testimony that she took the Coast Guard Auxiliary training. So she was not, that was not a significant break in the in any type of treatment. She, she did receive spinal surgery about a year and a half later, and then she never made it to Penn State. She ended up going to Borough of Manhattan Community College. She continued to suffer extreme pain as a result of her cervical spine injury. She took some time off, and as the record reflects, she became pregnant. So there is some reasonable explanation for a break in chiropractic treatment. She says that she couldn't lay down on her stomach. This was not advisable under the circumstances that she was going to have she carried the child to term. When she was done, she continued to go to her treatment. She saw her doctor. She was immediately given a type of injection to treat her spinal injury. And
Do you have anything further?
no,
Okay. Okay, thank you.
thank you.
Good afternoon again. If I could address some of the points that were made. With respect to the issue of plaintiff's immigrant mother and that alleged explanation, that doesn't explain the first 13-month gap where she didn't treat for a cervical spine, and then also the gap with respect to the right knee. With respect to the right knee injury, again, the court made a note of it. The only explanation that we have is a one-sentence statement from Dr. Benatar stating that there's an aggravation, even though the lower court found specifically that we've established our prima facie finding that she did not sustain that right knee injury. And having a one-sentence conclusory statement stating that an opposite to that is not enough. And then with respect to the cervical spine and the right knee as well, Dr. Waite, the biomechanical expert, should have been considered by the lower court. It's completely unrefuted by plaintiff in their papers and Dr. Benatar. And specifically, I just want to highlight the Carter versus Full Service Inc. case. And in that case, again, although there wasn't a biomechanical expert, defendant's doctor, the expert, the orthopedic surgeon testified that there was not enough force to have caused the injuries that was sustained by the plaintiff in that case. The same that Dr. Waite says in this case, through peer-reviewed articles and testing. And the court held specifically that since the accident did not generate sufficient force to cause such an injury.
Counsel, she did testify that she banged her head against the dash, correct? As a result.
There's no head. I don't recall that specifically, Your Honor.
I think that's in the record.
But in any event, Your Honor, Dr. Waite's report's not rebutted. So even if that's true, Dr. Benatar nor any of the other experts say that caused the cervical spine injuries. Dr. Coyne highlighted specifically that it was...
Doesn't the expert have to base his opinions on the facts?
Yes.
So then he should take into consideration what the plaintiff testified in her deposition, that she banged her head.
Your Honor, he did. And he still found that there wasn't sufficient force. And there is no expert on the other side. I'm a layperson. I can't give an opinion as to that. Only experts can. So if our expert, who's not rebutted, says that didn't cause the injury, plus we have a degenerative condition that Dr. Coyne noted, which their expert doesn't even address, Your Honor, that's not sufficient to establish material issues of fact in this case.
Okay, we will take a look at the papers again. Thank you both.
Thank you.
Next case for argument is Picardo versus Irizarry. Good afternoon.
Good afternoon, Your Honors. May it please the Court. My name is Yelena Genshinok, and I represent Plaintiff Appellant Eric Pena Picardo in this matter. Your Honor, this is a case of 100% undisputed and unequivocal liability on the part of the defendant respondent, which the trial court failed to recognize, thereby denying the plaintiff's motion for summary judgment on liability. There is only one version of the evidence, and the court below committed reversible error when they found that there's conflicting versions as to how the accident occurred. The defendant never attributed any fault to the plaintiff for the happening of this accident. The trial court failed to recognize—
On the contrary, right? He said it was all his fault?
Correct. And the trial court failed to recognize that the defendant's version of how the accident happened was substantially similar and corroborated the plaintiff's testimony. Your Honors, this case involves a rear-end collision. The two vehicles were traveling in adjacent lanes on Lexington Avenue. The defendant's vehicle was in the right lane, the plaintiff's vehicle was in the left lane. The accident occurred when the defendant's vehicle attempted to change lanes from the right lane into the left lane.
Do the pictures show, I mean, for purposes here, do the pictures show a rear-end collision or maybe a side swipe instead?
So my client never claimed that it was a flush rear end, but the damage to the vehicle, and he testified to this as deposition, was to the rear right corner of his vehicle. So my client was proceeding straight in the left lane. There has been no testimony that the defendant's vehicle was in front of my client's vehicle at any point. My client was proceeding straight, and as the defendant's vehicle was changing lanes, he did not wait for the plaintiff's vehicle to fully go in front of him, and he began to change lanes.
There was a lot of traffic on Lexington at the time, and there was somebody in that right lane blocking them, which I've seen happen many times. But they weren't going very quickly either, were they? Either of your drivers.
My client didn't see the defendant's vehicle. The plaintiff didn't see the defendant's vehicle. He can't testify to how fast he was going. My client claims there was traffic, but he was definitely moving more than 1 mile per hour, which is what the defendants claim. Nonetheless, no matter how fast or slow they were moving, both were going under the speed limit. My client didn't do anything wrong. He in no way contributed to the accidents. He in no way had any duty to see what there was to be seen behind him in the next lane as he was traveling in heavy traffic, in his own lane, minding his own business as an innocent driver. There was no testimony, contrary to what defendants state in their respondent's brief, that the defendant's vehicle was at any point in front of the plaintiff's vehicle before the accident happens. The nose of the defendant's vehicle was never in front of the plaintiff's vehicle. There was nothing from my client to try to avoid as the impact came from the back. And so, it's my assertion, the plaintiff's assertion, that the lower level, they extended a duty to my client that doesn't exist. I understand there's a duty to see what there is to be seen. I understand if the defendant's vehicle was in front of my client's vehicle, was changing lanes at the time that the collision occurred, but my client didn't see that as the impact happened from the rear. So there should be no such duty extended to my client to see what's happening behind him in the other lane. Once again, the defendant was asked at his deposition, did my client do anything wrong? He said no. He apologized to my client. He said that the reason that this accident occurred was because nobody was letting him through. And respectfully, Your Honors, Section 1128 states that a vehicle should not move into another lane until it's sufficiently safe to do so. There's no, there is no additional language that says unless there's heavy traffic and then you do what you have to do and try to squeeze in. He should have waited. He was impatient. He was trying to squeeze in. He was trying to get into that lane, admittedly because nobody was letting him through, but that shouldn't be on my, that issue should not be my client's problem. The defendant shouldn't hide behind the emergency doctrines. They also claim in their brief that because my client stopped short, that's why that collision occurred. But admittedly, both vehicles were in stop-and-go traffic, so the defendant should have foreseen that there would come a time, potentially, that my client would have had to stop, maybe even stop short if something in front of him happens, and he should have left enough room between the front of his vehicle and the rear of my vehicle, the plaintiff's vehicle, to be able to stop in time if such a even short stop had occurred, and he did not, because he admittedly started to change lanes before my client had cleared his vehicle, in violation of 1128, Your Honors.
Okay, thank you. We'll hear from your adversary, and then you'll have a little time if you'd like to respond.
Good afternoon, Your Honors. May it please the Court, my name is Eric Tosca, the Law Office of Kelly, Road and Kelly. We represent the respondents in this matter, Juan Irizarry and Bronx City Recycling. Your Honors, if I may address a point regarding the motion itself, and why I think Justice Barbato had, and he noted it in his decision, that the predicate to that motion, the narrative, is completely different than what really happened. There was no following too closely, which is the mainstay of the motion that was made against the defendants. The version that's offered as the predicate to the motion is that the Bronx City vehicle was following behind Mr. Picardo's vehicle, but that's not the case. On their own record, there's testimony and the police report itself, which was uncertified, which contests that this was a case of following too closely. And so when we look at the motion itself, it fails because it contradicts itself. Regarding, though, the issue of what happened at the scene, the inferences can be drawn most favorably to the non-moving party. And if we get past the deficiencies in the motion itself, I respectfully, refer this honorable court to the testimony of my client driver, Mr. Irizarry,
Let me just ask
where
you
he
about
said,
the testimony of the defendant driver. I mean, he testified that he was trying to move to the left lane, the plaintiff's vehicle was moving but not completely ahead of him. The other vehicles wouldn't let him pass, traffic was heavy, he was moving little bit by little bit, and then he hit the rear part of the vehicle with the front of his bumper. It seems to me that the defendant in his own testimony has established the liability for the plaintiff.
okay, except the inferences that could be drawn, Your Honor, are in a light most favorable to the non-moving party. There was a testimony additionally by my client that he had his left arm out, he was signaling, he was trying to get behind double parked cars in the right lane, and he was moving little by little over to the left lane. It was a difficult task, to say the least. Now, for Mr. Picardo not to have seen this Mack truck trying to get over to the left lane would be simply...
The facts show he didn't cut in front of Mr. Picardo. He hit him from, on the side of the back of his car. So, like, Mr. Picardo might have been looking forward, which is what you want to do when you're driving.
Well, understand this, Justice Moulton, there were vehicles that had passed while my client has his arm out, while my client has the signal, while he's trying to get through. He said there are vehicles that would not let him go.
Well, honestly, Counsel, that does make sense. I mean, I don't know if you've ever driven down Lexington Avenue with a lot of traffic.
Unfortunately, I have.
Trying to get into the lane and people not letting you in, surprise, surprise. So, I can envision what's happening here, but I'm sure we've all seen it if we drive.
Justice Captain, the point I was trying to make, though, if I may, is that Mr. Picardo would have had to have seen, since there's heavy traffic, he's going 1 mile an hour, he must have seen this truck and the handout extended.
Maybe he didn't, I don't think there's a law that says you have to let the guy in if he's trying to get in with it, if he has his left arm out, because you have to be a nice person.
But certainly there's an expectation.
I don't think your client, Counsel, I'm sorry, but I don't think your client ever testified that the vehicle Mr. Picardo was driving was behind him at any point. The first time he saw him right next to him, to the left, and then he was a little bit ahead of him. So when he moves the truck into the left lane, he already knows that the vehicle Picardo is driving is on the left and ahead, in front. Nowhere in the transcript, and I read it, did he ever say that the vehicle Picardo was driving was behind him and didn't let him through?
But if I may, Your Honor, that's the first time he saw it. However, by necessity, Mr. Picardo had to be behind those other vehicles that would not...
That is speculative, because that is not reflected in any of the transcripts.
Well, I respectfully disagree. I think it's a reasonable inference.
Well, I can read to you from the transcripts, from the relevant sections, and the only thing that is there is that Picardo is on the left, your client is on the right, there are vehicles double parked on the right lane, and he moves into the left and he strikes Picardo's vehicle.
Okay. Well, Your Honor, I respectfully disagree with that. But if I may, I have one other point I would like to make if I may have additional time, and that is, number one, at some point, the two vehicles were bumper to bumper. And if we go to 196 of the record, where my client testifies that at some point, his vehicle and the vehicle of Mr. Picardo, he touches him, he doesn't even think he's touching him, and at that point, Mr. Picardo knew that there was a vehicle next to him, and yet continued to move forward, and it was he who caused the scrape. And I think that the testimony at page 196 of the record bears that out, Your Honor.
Okay. Thank you.
Your Honor, Your Honors, I just have a few points to make. There was no necessity for the defendant to move into the left lane. The defendant testified that he entered Lexington Avenue from, I think, at least a block back. And he was asked specifically, were you able to see down the block? He says for most of the block. So he saw that there were double parked vehicles in the right lane. He waited until he was a car length behind that vehicle to try and change lanes. And once again, there's no emergency situation. There's no requirement for any driver on the road to let somebody else into their lane. And as your honors pointed out, there was never any testimony that the defendant's vehicle the defendant's vehicle was ever in front of the plaintiff's vehicle for the plaintiff to see. The way I envision this in my mind is that the defendant's vehicle is here and the plaintiff's vehicle is always ahead of the defendant's vehicle, and they're kind of moving along on Lexington Avenue. There was no testimony at any point, even by the defendant, that the plaintiff saw or that their vehicle was in front of a plaintiff's vehicle to see. Furthermore, the defendant testified multiple times, and he says that he was asked a question, when the accident occurred, was the black SUV moving? This is on page 184 of the record. He says, it's because I can't tell, because he was moving little by little, and that's when I was moving little by little, and that's when I hit him in the corner, in his rear corner. He says it another time on the same page on the bottom. He's asked again, since you were moving so slow, or he was asked if the black SUV was moving ahead of you, why did you hit him? And he gives a lengthy response, and at the end he goes, and that's when I hit him with his right part, and that's when it got scratched. So there was never also any testimony that the plaintiff's vehicle in any way hit the defendant's vehicle. And for that to happen, the defendant's vehicle was in the left lane when it shouldn't have been, as the plaintiff's vehicle did not clear the road before he proceeded into the left lane. So respectfully, your honors, I ask that the decision of the lower court be overturned, that my client be granted summary judgment on the issue of liability, and that all affirmative defenses with respect to comparative fault be stricken. Thank you very much for your time.
Okay, thank you. Thank you both. Have a nice afternoon. Next case is People versus Kevin White.
Good afternoon, Your Honors. For Mr. Kevin White, the Legal Aid Society by Andrew Alexander, with Your Honor's permission. Your Honors, I would like to briefly discuss point 1 of the appellant's brief regarding Mr. White's participation in treatment. The prosecution failed to meet their burden at the SORA hearing of proving with clear and convincing evidence that Mr. White had refused treatment. Instead, the evidence at the hearing showed that he enrolled in treatment for over a year in aggregate, that he was a motivated participant, and he accepted responsibility for his offense.
He was removed 3 times, though, correct?
That's correct, and that was for unrelated disciplinary infractions that were not related to his willingness or engagement in the treatment program. And as
What inference should we draw from the fact that he wrote that letter to docs about the program was a waste of time, essentially? He said it was an unnecessary evil, which is a hindrance to its participants.
I do acknowledge that there is, that letter is part of the hearing record, Your Honor. On the other hand, the record also contains over 100 pages of treatment records that show first, that he had enrolled in the program. By the case summary's own recitation of his enrollment period, he was in the program at a conservative estimate, for about 13 months. And importantly, and this goes to what the guidelines require, it shows that he has accepted responsibility for his conduct, that he did not minimize his actions in this case, and that's really the kind of thing that the guidelines is concerned with here.
Didn't he actually sign something, and I thought he didn't even dispute it at the hearing, that he signed a form saying that he refuses to go back into the program? I mean, if he refuses to go back into the program, how do you get past that?
So let me just backtrack for a moment here in order to address Your Honor's point. The purpose behind assessing points under Factor 12 is to assess whether the client has accepted responsibility for the conduct and can be rehabilitated here. And the premise being that if you're a poor prospect, if you are not accepting the misconduct, then the likelihood of a reoffense is greater. Here, specifically just pointing to the records that were in evidence, there were over 100 pages here that showed that he really worked here to address the thoughts, the behavior that led up to the offense. He had identified possible triggers. This is pages 62 through 63 of the the program records, that he identified possible triggers and high-risk behaviors as well as maladaptive coping responses. He recognized underlying feelings, problematic feelings leading up to the offense. And most importantly, pages 102 and then 112 to 113 of the records, he credited the program for changing his views towards—
Counsel, if I may, what is your response to the program evaluations that said he needed improvement, and he called those erroneous and false?
So the letter that's referred to, I believe that is one letter that was, I think, written in December 2013, whereas the treatment records range in time from October of 2013 to February of 2014, and that's just really a portion of the time that he was enrolled in the program. So on the one hand, you do have this letter that is part of the record. But on the other hand, I would argue, for one, while the letter expresses his frustration, perhaps his criticism of the program, it's not a refusal of treatment.
Let's talk about the refusal for treatment, because he entered the program, I believe, for a fourth time in December of 2016, but I think that was December 12th. And then he refused to continue only, 6 days later, right on the 18th.
So actually, Your Honor's question leads me to sort of my second point here, which is the deficiency of the prosecution's proof. Primarily, the prosecution relies on a program printout that's part of the record and a single typewritten statement that says refused program. And SORA hearings, of course, proceed under the reliable hearsay standard. So you can meet your burden here, the clear and convincing burden, with hearsay documents. But however, there has to be indicia of proof, indicia of reliability in the record here. We don't know who the author is of that statement. We don't know the context in which that statement was made. We don't know if the author acted with a duty to report truthfully and reliably to the court. And the prosecution has the ability to procure better evidence to meet their burden. They just didn't do it here.
Okay, thank you,
If there
counsel.
are no other questions, I rely on my brief as to all other points. Thank you.
May it please the court, Claire Lynch for the people. Your Honors, the SORA court properly assessed 130 points and adjudicated defendant a level 3 sexually violent offender, and that decision should be affirmed. Defendant used fear and physical violence to prevent the victim from leaving his own apartment. Defendant attacked and robbed the victim and then brutally assaulted the victim. He's at a great risk for reoffense and should remain a level 3 offender. The court's assessment of 30 points for Factor 1 for being armed with a dangerous instrument was proper. Defendant was armed with several dangerous instruments during this continuous assault up to and just before he sexually assaulted the victim. He repeatedly hit the victim.
Why don't you focus on the factor that we just discussed with your adversary, under Factor 12, whether or not he refused treatment. I mean, there seems to be an argument being made that he didn't, in fact, refuse treatment. He was assessing how he felt about the treatment, and it can't be viewed that way.
Absolutely, Your Honor. So defendant was removed from the program 3 times for disciplinary reasons, as counsel mentioned, and in 2016, as you mentioned, rejoined the program. 6 days later, refused again. And that was 2016, and he never returned to the program. He was released in 2019. So again, he never completed the program, never returned. And I think it's important to note that defendant would be a level 3 offender even if not assessed the 15 points for factor 12. He would still remain a level 3 offender. So the argument is really moot. And if your honors have no further questions, I ask that you affirm. Thank you.
Thank you. Thank you both, counsel. The next case for argument is Footman versus D'Onofrio General.
Good afternoon, Your Honors. May it please the Court, Jack Newhouse for Plaintiff Appellant. The trial court improperly dismissed the defendant, D'Onofrio, from this action pursuant to CPLR 3211A1 and 7. And there's a single cause of action in this case, and that's a third-party beneficiary breach of contract claim for prevailing wages. The complaint contains all the facts necessary to assert such a claim, including...
And such claims have been repeatedly upheld by our court.
Yes, Your Honor.
Roble is a very prominent example.
Exactly, and Roble is an example, and it was cited in our brief specifically to show that the employment relationship is really not a relevant factor for whether plaintiff adequately pled his breach of contract claim against D'Onofrio. In Roble, the plaintiffs were asserted a claim against a general contractor, but they were employed by the subcontractor. And Justice Scarpula issued the decision for the trial court, and she held that was a permissible claim, citing to two other decisions. One was the Lane versus KBC contracting, and the other decision that was cited was Suarez versus USA Roofing, which is a Justice Singh decision. And then it was subsequently affirmed by the First Department. And so plaintiff adequately pled his claims as a third-party beneficiary, and the documents submitted by the defendants in support of dismissal are payroll records by one of the contractors, Sunset, who is not part of the appeal, and the other was articles of incorporation. But these documents really don't have anything to do with plaintiff's breach of contract claim. They relate primarily to the defendant D'Onofrio's arguments, which was that plaintiff failed to allege an employment relationship with D'Onofrio and failed to demonstrate an alter ego violation, alter ego liability between Sunset Park and D'Onofrio. But ultimately, whether plaintiff failed to demonstrate to assert facts sufficient to support those statuses is irrelevant to plaintiff's breach of contract claim. Nevertheless, as set forth in plaintiff's brief, plenty of facts were asserted in the complaint to support an employment relationship and to demonstrate the existence of an alter ego relationship between Sunset Park and D'Onofrio. In addition to that, I would just note that there were some other procedural issues with the trial court's decision. One is the improperly considering affidavits in support of defendant's affidavits in support of dismissal pursuant to both A1 and A7, which is improper. In addition, improperly disregarding the allegations in plaintiff's complaint because the complaint was unverified. Plaintiff does not have to file a verified complaint. In addition, there was this additional obligation that the trial court put on plaintiff, which was to submit evidence, to submit an affidavit, to submit these contracts. And that's not an obligation that's on a plaintiff in opposition to a motion to dismiss pursuant to CPLR 3211A1 and A7. Had the court wished to elicit that sort of proof from plaintiff, a notice would have had to be given pursuant to 3211C. And unless your honors have any further questions, plaintiff will reserve the right to argue on rebuttal.
Okay.
Thank you.
Thank you.
Good afternoon, excuse me. Good afternoon, Your Honors. May it please the Court. I'm Adam Birnbaum of Abrams Fensterman, and I'm representing Respondent D'Onofrio General Contractors. I want to address a couple of points. First of all, the material that the respondent submitted in support of its motion to dismiss was obviously being used for two different purposes. We moved under 3211A1, but we also moved under 3211A7. There were documents that were submitted which were either public records or were properly authenticated business records that were properly submitted under 3211A1. And for that purpose, the affidavits that were submitted merely laid a foundation for the submission of those records. And as far as 3211A7 is concerned, I'm sorry, I've gotten my statutory
We know what you
sections
mean.
backward.
Basically, the factual allegations by the D'Onofrio father and son don't count as documentary evidence.
Of course not, Your Honor, and I think everybody understands that. But nonetheless, if documentary evidence is to be adduced, a foundation has to be laid, and the affidavits were sufficient for that purpose and no other purpose when it comes to failure to state a claim. As far as the question of alter ego and joint employment liability is concerned, we take the plaintiff's complaint as we find it. A significant portion of the complaint was concerned with alter ego liability and joint liability. The 4 factors for the economic reality test were recited virtually verbatim in the complaint itself. And so it is odd that having authored and submitted this complaint, that now the plaintiff is taking the position that his own pleading consists largely of surplusage and that addressing the allegations and arguments contained in the complaint is of no moment. The plaintiff seemed to be making out a case for alter ego and joint employment liability by squarely addressing the elements of the test to establish whether such a theory of liability exists, and we addressed it in our motion. But we also addressed the sufficiency of his allegations. The complaint is remarkable because while it alleges that D'Onofrio General Contractors was engaged in work which is governed by the labor law and for which a prevailing wage contract attaches, and while he alleges that he performed work at job sites where D'Onofrio was present and where D'Onofrio trucks and equipment were used, separate and apart from what Sunset General Contract was doing, nowhere in the complaint does he actually say, and if you review the complaint, this might be surprising because it's perhaps written between the lines, but it's not stated outright. He doesn't say that he worked at any job where a prevailing wage contract attached. He recites 3 locations, doesn't give the date that work was supposedly done, doesn't say what he did at those locations, and doesn't say that that work was governed by any prevailing wage contract. That is squarely failure to state a claim territory. As far as Justice Love's observation that the complaint was unverified, that's a statement with some consequence. When D'Onofrio General Contractors submitted admissible documentary evidence in support of its motion, the burden, insofar as D'Onofrio was able to establish anything, shift to the plaintiff, and the plaintiff's complaint was unverified, which means that in response to admissible evidence, the plaintiff rests on the allegations, the unverified allegations in his complaint at his own peril. D'Onofrio introduced documentary evidence that squarely refuted certain allegations made in the complaint, that the 2 companies shared offices, that the 2 companies had officers in common, that the 2 companies jointly paid him. And he even goes on to state that his checks came from Jerry D'Onofrio. I'm sure it doesn't escape.
Was there documentary evidence that addressed whether or not these were prevailing wage contracts? There wasn't, I don't think.
No, there wasn't, Your Honor.
Okay, so that's alleged in the complaint. This is a pleading motion. Why isn't that enough?
Well, it's alleged in the complaint that those contracts existed, but Mr. Footman doesn't allege that he worked any of those contracts, Your Honor. He just states that he worked at 3 job sites in Manhattan and nothing else.
I'm not sure about that because my reading indicated that there was a contract with utility companies, right? And that those utility companies were required to pay the prevailing wages. Okay, I see you're nodding your head, so you agree with me on 2 points. And then lastly, that work was performed in furtherance of those contracts. Are you gonna nod your head again on that? Or are we gonna disagree?
I believe, Your Honor, that I'm looking at the same section of the record that you're looking at. And I have reviewed these allegations in some detail. And I do see an allegation that D'Onofrio was engaged in contracts where prevailing wage rules applied. I do see a separate allegation that the named plaintiff, and remember, this is a class representative, allegedly, so certain of the allegations attached to the class and certain of the allegations attached to him individually, but he doesn't say outright anywhere in this complaint that he worked prevailing wage contracts.
You know what? We're going to respectfully disagree with that because I don't see what else you would need in light of the Walbrook case, but we'll see.
Thank you, Your Honors. If there are no further questions.
Thank you, counsel.
Thank you.
Okay. I would just briefly note that paragraph 44 of the complaint explicitly states that named plaintiff worked for D'Onofrio defendants on numerous projects pursuant to prevailing wage contracts, mandating the payment of prevailing wages and supplemental benefits. And paragraph 45, which is immediately following it, identifies 4 project sites which are non-inclusive, just it's 4 examples of project sites clearly putting defendant D'Onofrio on notice.
Include but not limited to, as you
Exactly,
said.
exactly. And it's sufficient to put defendant D'Onofrio on notice pursuant to CPLR 3013, 3013, notice pleading standard of what we're alleging here. And so D'Onofrio could easily look in the records and they have an understanding of what projects these are. And they could have come back with more documentary evidence, perhaps, if they wished to have created a greater record. In terms of the foundational issue, the portion that was cited by the trial court from from Sunset Park's owner states that plaintiff was employed solely by Sunset at all relevant times. And so I understand the need for some sort of foundation that, okay, Sunset's payroll records. And so, of course, Sunset says he's employed by us, and thus here are the payroll records. But solely is the imperative word here. That is not foundation for Sunset's payroll records, that they were the exclusive employer of plaintiff. Plaintiff alleges, of course, that D'Onofrio was his employer, and so the documentary evidence, which is the payroll records, is not inconsistent with plaintiff's allegations. Plaintiff alleges that he was paid by Sunset Park. So, of course, the payroll records are consistent with that. In addition, the articles of organization are not inconsistent with plaintiff's claim, and that is because plaintiff acknowledges that they were incorporated under separate names, and they are just different corporations. That doesn't mean that they can't also be alter egos or joint employers. Thank you, Your Honors.
Okay. Thank you. Thank you both. People versus Pedro Ortiz.
Good afternoon, Your Honors. Whitney Elliott of the Legal Aid Society for the appellant, Mr. Pedro Ortiz. In this SORA case, the prosecution did not carry its burden of proving by clear and convincing evidence that Mr. Ortiz had a history of alcohol abuse, or that he had abused alcohol at the time of the offense conduct here.
But didn't he make a statement saying that he was probably drunk when he committed the offense?
So, a few things about that, Your Honor. So the case summary does contain a statement written by the board member who prepared the case summary that reported at his prison intake interview, he stated that he was, quote, probably drunk when he committed the offense. That doesn't amount to clear and convincing evidence that he was, in fact, drunk.
That's not an admission either.
So, no. So, number one, by its terms, that statement is a vague and tentative statement about whether he was drunk at the time of the offense conduct. Second, as we point out, in our view, an equally plausible inference for why he made that statement was out of embarrassment or shame when he was sitting for an interview while he was entering prison about his offense conduct.
Counsel, I'd just like to go back and follow up with my colleague about the alcohol abuse, because he certainly said that he was probably drunk, but didn't he also report a history of alcohol abuse? And if I'm not mistaken, he was like 67, and he had indicated, I think, weekly alcohol use beginning at age 16 to 20, right?
So a few things about that. I just want to unpack a couple of different parts of the statements. There is the statement, which is what the court relied on, and the only thing that the prosecution argued below was that there was a report from his prison intake interview that he reported a, quote, history of alcohol abuse. But that was undermined by other more reliable evidence. Namely, he scored in the no problem range on the...
But what could be more reliable than the words out of a person's mouth? That's what the defendant said.
Well, for a couple things about it. It doesn't actually reflect his actual statement. It's the board's description of what a DOC's staff member said.
What he reported, right?
Of what a prison official said he reported, but we don't know what his actual words were. And he had referred to, in his pre-sentence report and in his substance abuse evaluation, that he was a weekly user of alcohol from the ages of 16 to 20. Now, the prosecution didn't argue below that a weekly use from those ages amounted to abuse, and the court below didn't find that. They just relied on the general statement that he had a history of abuse. We don't know what the basis for saying he had a history of abuse. It may have been that same weekly use, but there was no finding below that weekly use amounts to abuse under the guidelines, and that's right, because Palmer holds that periodic moderate drinking does not amount to abuse under the guidelines.
Right, but in that particular case, at the time of the incident, the defendant didn't say that he had been intoxicated. Here, we have a statement, self-reported, that he was probably drunk during the time of the incident, and isn't that a factor that the SORA court can consider?
I mean, it's certainly relevant, but again, I think by its terms, the probably drunk is a vague, tentative statement by its terms.
When he combines it with a reported history of alcohol abuse, that's what he reported. He reports a history of alcohol abuse. He reports a history of drinking weekly. And then he says, I was probably drunk when I did this. So when you combine all those things, the totality of all those, of all that information, wouldn't that be sufficient for the court to have assessed the points for alcohol abuse?
No, Your Honor, and this is actually a critical point. We point this out in our reply brief. The history of abuse and abuse at the time of the offense are two independent standards. So they need to be assessed separately, and we don't think they can be combined. So, yes,
Okay.
Thank you, Your Honor.
You'll have a minute on rebuttal. We'll hear from the people. Thank you.
Good afternoon, Your Honors. May it please the Court. Noah J. Sexton on behalf of the respondent, the Bronx County District Attorney's Office, appearing under the supervision of ADA Reva Grace Phillips. To start off, I would like to make it clear that this is not a Palmer situation. This is not a Long situation. This is a situation, rather in those cases, we need to remember. What was being talked about was defendants who, they had a couple drinks. One of them had a drink at a party the day of the offense. There was no statements as to a history of drinking beyond social drinking. No statements as to, oh, I was drunk at the time of the offense. Really what was said in those cases didn't leave any room for any court to make a determination as to what role alcohol may have played in the offenses. In this situation, we have a defendant saying unequivocally, I was probably drunk.
Now, he says it was reported that way because it was written down during an interview. Did the defendant ever deny that this is what he said at the time?
Nothing that we have seen has indicated that he denied he said that. And frankly, turning to the point that my adversary brought up that, perhaps he was embarrassed and he said that, there's nothing on the record that would support that notion. I mean, it's pure supposition. Of course, that could possibly be an explanation, but by all indication, he was referring to the fact that he was probably drunk when he committed this offense. In doing so, demonstrating that he himself believed that he might have suffered from the same sexual disinhibition that the guidelines are concerned about when he decided to molest a 4-year-old girl. I would also like to point out that, the people have never, tried to contradict the statement that the masked report said it was no problem. But we are saying that it is not dispositive, as our adversary seems to think it is. Fundamentally, this does not undermine the fact that defendant said, "I was probably drunk." This does nothing to negate the fact that he admitted to abusing alcohol starting at the age of 16. Nothing that has been offered really does anything to speak to those two things, and none of the arguments or possible other explanations are supported on the record. Now, I would also just like to turn to the claim that this is vague. I mean, Your Honor, this truly isn't vague. This is not a situation where the defendant is saying, "Oh, maybe I was drunk. I might have been drunk." Or like Palmer, "I had a few drinks that day." This is a defendant stating unequivocally, "I was probably drunk when this happened." It doesn't get much clearer than that, especially when taken in light of the fact that he has a history of substance abuse dating back from the age of 16. And while we do acknowledge that those two things, cannot be combined to meet a single burden of proof, we've met our burden of proof on both of those points, totally individually. This is just one of them bolsters the other, essentially. We have these statements. We have nothing in the record contradicting what was said. We have nothing in the record indicating that DOCCS either made a mistake or had some kind of reason to inaccurately report what was going on. Everything else amounts to little more than supposition. Now, unless Your Honors have any other questions for me, I will leave the rest of my argument to the papers. Thank you.
Okay, thank you very much.
So just a couple quick points in rebuttal, Your Honor. First, in terms of the under the influence at the time of the offense and the Palmer question, this is a Palmer situation. The statement, "I was probably drunk," is not clear and convincing evidence that he was in fact drunk. And there could be more specific evidence, and Palmer talks about it. Evidence of how much the person drank, whether they in fact became intoxicated, whether there was a causal relationship between the drinking and the offense conduct. There's none of that here. There's just a vague statement from someone at a prison intake interview, "I was probably drunk." That's not clear and convincing evidence. And second, Mr. Ortiz did not admit to abusing alcohol since the age of 16. He said he was a weekly user from the ages of 16 to 20. That's his statement in his pre-sentence report, pre-sentence interview, and also in his substance abuse evaluation, that he was a weekly user. That wasn't an admission to an abuse. We also don't have here anything like any prior diagnoses, even though he had a substance abuse evaluation while in prison, apart from the ASAP program in prison. No past treatment, no discipline, no convictions. There's not clear and convincing evidence here. Thank you very much.
And you said you were appearing under the supervision, so does that mean you're still in law school, or you're not here? Okay, well, maybe you'll see one of us there on this, the big screen. But thank you very much. Congratulations, good luck, and thank you both, counsel. Okay, and our last case for argument this afternoon, Lugo versus the Housing Authority.
Good afternoon. May it please the court. Patrick Lawless for the defendant appellant, New York City Housing Authority. Supreme Court should have granted NYCHA's motion for summary judgment. The evidence in the form of the witness's testimony and the maintenance records show that NYCHA did not create or have actual or constructive notice of the broken pipe.
Well, now, there were pictures in the record of a really very deteriorated pipe underneath the plaintiff's sink, which I know was replaced shortly thereafter. Your client said, "We never patched those, we replaced them." Nonetheless, this was the pipe that was found at the time of this incident, and there was indication that there had been work before and that she had made complaints. So doesn't that at least create an issue of fact?
No, it doesn't, because the plaintiff testified she only made a single complaint. There was only a single service call, and that was a clogged drain, and she watched the NYCHA maintenance worker clear it with a hand snake. That was it. The plaintiff testified there was never any other problems with the drain after that. She never saw any patching, and more importantly, NYCHA's maintenance worker, Mr. Hernandez, performed an inspection of the entire apartment, the yearly inspection,
Right.
in January of 2019, which was 10 months before the accident. He specifically recalled examining the kitchen sink and the drain pipe underneath. He specifically stated there was no
Counsel,
patching.
you've got a lot to work with at trial, for sure, but you've got the photos, which are tough for you, and then you have the expert, Mr. Krongleb, saying he saw traces of adhesive around the hole. So, I mean, isn't that enough to create an issue of triable fact? I'm not saying you don't have plenty to work with at trial, but, you know, we're talking about summary judgment.
Well, that happened after NYCHA's last inspection. NYCHA had no notice of that condition prior to that. And Mr. Krongleb, first of all, he has no experience or doesn't set forth any qualifications as a plumbing expert. He relies on the single photograph, which was taken. If you look at the testimony, it indicates it was taken by plaintiff's attorney a month and a half after the incident. The plaintiff herself said immediately after the accident she took photographs. There is no white milky substance emanating from the pipe, and she didn't see any patching. Mr. Krongleb,
He also, on the motion, put forth an updated affidavit, and you guys, I mean, I imagine you're not the trial attorney in this case, but you never came up with any expert to rebut or deal with any of the points that he had made on this.
it's entirely speculative. He never personally examined the pipe. The plaintiff's attorney visited the plaintiff's apartment a month and a half afterwards. The pipe was replaced shortly thereafter. There's nothing to indicate that the pipe was requested to be saved so it could be inspected. The plaintiff's expert, again, who doesn't set forth any qualifications as a plumbing expert, looks at a photograph and says that this condition existed for 5 to 10 years in direct contradiction to the testimony of Mr. Hernandez, who personally observed the pipe. Also, the expert makes these ridiculous legal claims that the building code imposes strict liability on landlords and doesn't require notice of a condition. His testimony is completely worthless. It's lacking in any probative value because it's all speculation.
I'm not going to rely upon him for the legal standards. I agree with you, but I'm dealing with him, just as to the pipe. So you've made some, you've made some good points, but I still wondered, wouldn't that at least raise an issue of fact, because he did look at the pictures. I don't really care who took them, but he did look at the pictures, and he saw some patching, which your people say they would never do.
Yeah, well, NYCHA workers all said that they never repair pipes with patching. They said that if it's broken or damaged, they would completely replace it. The plaintiff herself said, up until the time of the accident, she lived there. She never saw any patching on the pipe prior to the incident. She even testified immediately after the incident she didn't see any patching. So there's no notice. There has to be evidence, some evidence to rebut NYCHA's prima facie showing that there was notice, and all you have is the speculative conclusion of the plaintiff's expert, who again doesn't set forth the proper qualifications that he's an expert in indoor plumbing, to try and rebut that, and that's insufficient. Thank you.
Okay, let's hear from your adversary, and you'll have a couple minutes on rebuttal. Thank you.
Thank you. Thank you. Good afternoon, Your Honors.
Good afternoon.
May it please the Court. One thing that I don't think has been mentioned, which I think is the most important point here, is that without regard to what the plaintiff's engineer stated and the basis for his opinions, the motion for summary judgment completely ignored his report, which had been served before even depositions. Part of the record in the case before the motion for summary judgment was made was a detailed report by plaintiff's engineer, which determined that this looks to me like a failed patch. The motion was made, testimony was cited on behalf of the defendant, on behalf of the plaintiff. There was no mention at all made of plaintiff's expert's report, and that in and of itself, plaintiff submits is sufficient to deny the motion. The motion, the defendant's motion for summary judgment has to set forth a prima facie case based on all of the facts. They can't just ignore an engineer's report, make a motion for summary judgment, and then attack it solely on reply. The record before the Court on this appeal contains numerous attacks on plaintiff's engineer, and all of these attacks on plaintiff's engineer were made in reply at a point where the plaintiff had no opportunity to respond to those attacks.
I mean, he was an engineer.
Of course he's an engineer, and not only that.
I mean, I don't think he has to be a specialist in indoor plumbing. I mean, I think an engineer is okay. I mean, you know, that'll all be considered at a trial, but.
But aside from that, he did testify that he's entered buildings, he's used plumbing, he's taken basic plumbing classes. His testimony's been accepted as an expert concerning leakage in New York City buildings, concerning leakage caused by
Counsel,
faulty.
he only worked from the photograph, correct?
He did only work from the photograph.
Taking that as a premise, I mean, Mr. Rios and others said that it's NYCHA policy never to patch a pipe like that. And Mr. Rios said he inspected in 2019 and that the plaintiff signed off on the inspection. So isn't that evidence of isn't that direct evidence as opposed to the expert's reliance upon a photograph?
Yeah, but that's, I think, it's some evidence, but the problem with that evidence is that this is approximately a 1,700 unit development. And the testimony is that at the time of this accident in 2019, there were approximately 3 maintenance personnel for that whole development, 1,700 units. So testimony concerning what one of those people saw on one inspection, I just don't, I think that presents a real credibility issue for a jury. That would be plaintiff's argument. The other thing is that a lot of the cases that are cited by the defendants in support of the motion attacking the expert's report, I don't think are applicable here. But I think the major point is, first, there's notice from a view of the pipe. This is a long-standing condition. It's clear, I think, even to a layman by viewing these photos, that this is not something that just developed a day before or a week before the time of the accident. Clearly, it's something that is not explainable, but certainly something that's been there for a very long period of time. 10 months prior, the Housing Authority inspected this sink, and plaintiff's engineer says at that time, this was here in one form or another, so that there is notice. So plaintiff would argue that there is constructive notice. As to their first arguments, that there was no notice, that the motion should be granted for summary judgment. But more importantly, plaintiff's engineer, I think, has not been rebutted, and I think that was their obligation in the motion. They would have had to have at least brought up the fact that there's an engineer's report, not completely ignored it.
Any other questions? Okay, counsel, thank you very
Your
much.
Honors.
Mr. Lawless, you have 2 minutes.
First of all, the NYCHA's initial moving papers properly addressed the allegations in the complaint, and it properly addressed the expert's affidavit, which is specifically crafted in opposition to summary judgment, in which it incorporated his report and its reply. So there was nothing improper about that. There was no new arguments in the reply. And the expert was required to show that he had experience or expertise or was qualified to give an opinion with respect to plumbing. That's what the case law says. Just a general background in engineering isn't sufficient. He testified he was qualified to give an opinion because he's observed pipes and other inspections, but he specifically states in his affidavit and in his CV, that the scope of what his expertise was, and it didn't include plumbing. He also, the expert and plaintiff's counsel improperly attacked the credibility of NYCHA's witnesses, which is improper in summary judgment. You can't defeat a motion for summary judgment by attacking witnesses' credibility. There's nothing to refute the testimony of NYCHA's maintenance personnel that they never used patching to repair pipes. There's nothing to refute Mr. Hernandez's testimony that when he inspected the pipe 10 months before the accident, there was no patching and there was no issues with the pipe. Plaintiff's expert, who again, never personally inspected the pipe, is not qualified and cannot refute that testimony because he never personally inspected the pipe. He doesn't know what it looked like 10 months before the accident, yet he concludes that the pipe was defected at that time. That is insufficient to rebut Mr. Hernandez's testimony. Based upon that, summary judgment should have been granted to NYCHA. Thank you.
Okay, we will take a further look. Thank you all very much. Have a good afternoon.
What? Oh.